All right. Good evening, everyone. On behalf of Ashwa Legal Advisors LLP, I welcome all to this important webinar that we have on jurisdiction of DGGI. Before we start, as usual, I just like to provide a brief introduction about our firm, Ashwa Legal Advisors LLP. It was founded in 2017 by our founder and partner, Advocate CA Dr. Avinash Poddar and Advocate CA Anchal Poddar, and other partners in the firm being Shailin Doshi, CA Ashu Dalmia, CA Shefali Girdharwal, CA Vishal Poddar, myself, Advocate CA Pramod Dokania, Advocate Amish Desai, and Advocate Avdesh Sharma. We are basically a national level boutique law firm specializing in providing comprehensive legal assistance and litigation support across a broad spectrum of practice areas, and our expertise encompasses taxation, both direct and indirect, and GST in particular, prevention of money laundering act, PMLA, Benami related litigations, corporate laws including Companies Act and IBC, SURFACI, and other statutory litigations and legal services. Our firm is headquartered in Surat with branch offices strategically located in Mumbai, Delhi, Pune, Ahmedabad, Nashik, Vadodara, Faridabad, Gurgaon, and Rajkot. In addition to this branch network, we also maintain a robust network associate offices across India, enabling us to provide seamless legal services and comprehensive support to our clients spread across India. So with that brief introduction, I then hand it over to Vishal Bhai to take over the current proceedings on DGGI jurisdiction. Thank you.
I think Shefali ji will give the introduction.
All right.
Hi everyone, welcome to this specific webinar for Ashwa. And when we were deciding the topic of this particular webinar, we had many things in mind because a lot of people suffer from this question. The biggest term in GST, I will say the most dangerous word is DGGI. Like what will happen if they summon you for something? What will happen if there is a search from the DGGI? What are their powers? What are their rights? What is their exact jurisdiction? These are the questions which like many taxpayers have. And why it is more important, because generally DGI people are not taking these small cases. Most of the cases they will take up will based on some kind of intent. First thing. Second thing is they will be involving a huge amount. So you will see many fraud, the fake invoicing frauds or many kind of frauds. Whenever there is a huge kind of fraud. So recently we have a huge fraud in the Faridabad itself. So most of those cases are taken up by the DGI. So जब ये टॉपिक हम डिसाइड कर रहे थे, तो सबसे बड़ा क्वेश्चन ये था कि बहुत लोगों के माइंड में क्वेश्चन होता है कि क्या उनका पावर है, क्या वो आपको नोटिस सेंड कर सकते हैं, सर्च कर सकते हैं, क्या वो आपको एडजुडिकेट भी कर सकते हैं? अगर वो नहीं कर सकते देन लाइक टू whom the case should be shift, क्या उनको सिर्फ इन्वेस्टिगेट करने का राइट है? फ्रॉम वेयर दे आर ड्राइविंग देयर पावर, डीजीजे का होल पावर कहाँ से डिराइव हो रहा है, प्लस जुरिस्डिक्शन उनका कहाँ कहाँ पे है, किस एरिया में है? बिकॉज जनरली वी से दे हैव द ऑल ओवर इंडिया जुरिस्डिक्शन, बट जो ऑल ओवर इंडिया जुरिस्डिक्शन डीजीआई को है, वेदर इट इज ऑल्सो डिवाइडेड इनटू सब पार्ट्स, या कहीं की भी डीजीआई कहीं पे भी जाके इन्वेस्टिगेट कर सकती है. सो टू आंसर ऑल ऑफ दोज क्वेश्चंस वी प्लान दिस पर्टिकुलर वेबिनार. एंड इसके लिए हम लोग सबसे पहले वी विल वॉक थ्रू द प्रोविजंस जो एज इट इज अभी हमारे लॉ के अंदर है. पहले सबसे पहले हम लोग वो प्रोविजंस वॉक थ्रू करेंगे. एंड इसके लिए आई वुड लाइक टू रिक्वेस्ट विशाल जी टू प्लीज वॉक थ्रू अस टू द प्रोविजंस व्हिच आर गिवन अंडर द लॉ.
Thank you, ma'am.
Thank you.
Welcome everyone to another important series in our webinars. This is, you can say, the second part of our jurisdiction series of the Ashwa Legal webinar. So we had our first series on jurisdiction earlier, where we discussed about the basics of jurisdiction and the certain issues that are coming up when we read the sections 3, 4, and 5 of Central Act and the respective state acts. Now we go to a particular part in jurisdiction, that is the powers and jurisdiction vis-a-vis the DGGI. As ma'am just rightly gave you a brief overview and an introduction as to how we today are experiencing the exercise of jurisdiction by DGGI. So the first point to be understood is from where this jurisdiction is drawn. Now we all know under GST law, Proper officer is the term which is coined for the authority who has been empowered by the law to take any action under the law. Now, the proper officer is defined under Section 2, Clause 91 to say that it is in relation to any function to be performed under this Act, means either the commissioner or the officer of the central tax who is assigned that function by the commissioner in the board. Now, we all know what is commissioner in the board. It is the commissioner who's sitting in the North Block. So, the proper officer will be one of these persons, either the commissioner himself. The commissioner means commissioner of every GST department, as we have every central department has its own commissioner, or it would be any officer who is assigned this function, but by whom? By the commissioner in the board. Now, when we go through the law, the powers, the appointments are contained in section 3, 4, 5, and 6. Today, we are not going to refer to 6 because that is not much relevant to us. In fact, entire 3, 4, 5 is also not relevant, but we can draw some important pointers which will be the basis of our further deliberation and argument. So we'll just run through some important aspects of these sections. So section 3 says that the government shall by notification appoint the classes of person, and then it has given the list starting from the chief commissioner. But at the last it says any other class of officer as it deems fit. So this is, I believe, the first starting point from where you can say that the government gets the power from the Act to appoint any authority other than the one which are listed in section 3. Then we have section 4, which further deals with appointment of officers. Subsection 1 says the board, that is a CBIC, may, in addition to the officers as may be notified, what we just saw in point number 3, section 3, sorry, may appoint such person as it thinks fit to be the officers. So even the CBIC is empowered to do this. However, without prejudice to the provisions of this subsection 1, the board may, by order, authorize any officer referred to in the above clauses, what we just saw in section 3, to appoint officers of central tax below the rank of assistants. So 1, the board is also empowered to appoint the officers. 2, it can ask the officers who are already appointed to appoint the lower ranking officers. Fine. Nothing much, just a brief overview you should keep in mind. Then comes section 5, which deals with powers of the officers. Yes, one thing, those who wish to get into more detailings of 3, 4, 5, 6, we had an elaborate discussion on this in our previous series of jurisdiction, that is part 1. So we are not touching on to all those aspects now. Further, section 5, powers of the officer states that subject to such conditions and limitations as the board may impose, an officer of central tax may exercise the powers and discharge the duty conferred or imposed on him under this Act. First, officer of the central tax may exercise the power and discharge the duty conferred or imposed under this Act on any other officer who is subordinate to him. Now, for exercising this power, he will not require any specific notification or circular to tell him so. He can do it by himself. Third, the commissioner may, subject to such conditions, limitations as may be specified in this behalf, delegate his power to any other officer who is subordinate to him. Now, this is where I think will require some legal reference where it says the commissioner may, subject to conditions and limitations as may be specified, can delegate his powers also to the subordinate. Now, I think this will require some type of legal reference so that as a taxpayer, we should also know which commissioner has delegated what power to any other person. Now, this cannot be suo motu, or it cannot be just by the commissioner feeling so and asking somebody to do something. I think this point we need to keep in mind. And notwithstanding anything contained in this section, the appellate authority shall not exercise the powers and discharge the duties conferred on any of the officers because they are appellate authorities, they are not the adjudicating or the procedural compliance authorities. Now, the relevant notifications which will form the basis of our today's discussion is firstly, from where do this DGGI draw powers under the GST law? So it is coming directly from this notification number 14. However, when we will start, I'll just go to the previous notification to this, which is the main notification, which is distributing the powers between the different authorities and designating different authorities from different places. So firstly, it is notification number 14/2017, which notifies or which authorizes that even DGGI shall have the power to exercise certain powers under the Act. And then we have a circular 31/5. Then we have this notification 2/22 and notification 27 as well as 28/2024. Now, all these three basically deal with those cases where notice has been issued by DGGI. In that cases, who will be the authority to adjudicate on those notices? Now, here I would like to inform to all the members present over here that here notification 2/22, 27, 28/2024 says that where the notices are issued by DGGI, the adjudication can be done centrally by one officer. So basically, it caters to those cases like fake invoicing cases where multiple people are involved or multiple people are alleged to be involved, and where notices are issued on multiple notices. For them, these notifications says that there can be one single authority to do the adjudication. The precondition is that the notice should have been issued by the DGGI. Now, with this background, let me take you to the important notifications. Now, the very important and the first most basic notification is notification 2/2017, which says that in exercise of powers given under section 3 and 5, certain officers are notified. Now, here originally the notification said CBIC, then there was a corrigendum saying that it will be the government to align it with the section. Now, here, if you see, this basically notification divides the power and it authorizes different ranking of officers for different purposes. So firstly, it has given a list of all those authorities who are notified under the Act for the purpose of exercising different powers. Further, it says the principal chief commissioner or the chief commissioner, as the case may be, in column 2 of table 1, are hereby vested with the territorial jurisdiction over. So under a principal chief commissioner or chief commissioner, these, you can say, the lower level authorities would be falling. And most important, they have used the word territorial jurisdiction. It is very important to note that under GST, we first identify our authority on the basis of the territory to which the taxpayer belongs. This is what is territorial jurisdiction. And it is all coming out from this parent notification, I'll say. Further, it says the principal commissioner of the central tax or the commissioner of central tax, as the case may be, which is specified in column 2 of table 2, and the central officer subordinate to them are hereby vested with the territorial jurisdiction specified in the corresponding entry in column 3. Now, this, according to me, is an important table, which I'll just take you to so that you'll get a brief overview. And then third, it says the commissioner central tax appeals. I'm not concerned right now. Commissioner central tax audit, again, I'm not concerned. So firstly, in table 1, as you can see, the principal chief commissioner and who all would be coming under. And as you can see, it is divided area wise, that is the territory wise. So as you can see, under the first zone, which is Principal Chief Commissioner Ahmedabad, these are the different subcategories of Principal Chief Commissioners, etc., who would be falling. And similarly, they have divided entire India into around 21 zones at that time when this notification was brought in. Now, for me, this is the second important table, which says that territorial jurisdiction of now each of these commissionerates, let us say. So first, notification is empowering the principal chief commissioner and saying that the following persons would fall under them. And now each of the principal commissioner or the commissioner, what all areas would be falling under them. So under, for example, the principal commissionerate of Agartala, the entire state of Tripura would be covered. Similarly, under Agra, following districts of Agra would be covered. Under North Ahmedabad, following areas of North Ahmedabad would be covered. So this is how they have divided the jurisdiction on the basis of territory and empowered these different commissioners and then the authorities. Now, coming to this next important notification, which according to me is the most important notification for today's deliberation, that where exactly and how exactly the DGGI fits into this particular entire list. So as I first referred in section 3, the last clause said that any other person who is appointed, and I believe drawing the powers from that last clause, this particular notification has been issued, which says that in exercise of the powers conferred under section 3, read with 5 of the CGST Act and section 3 of the IGST Act. Now, this is what is the important point which I have highlighted. The CBIC hereby appoints the officer in the DGGI, Directorate General of Goods and Service Tax Intelligence, as the central tax officers. So DGGI are appointed as the central tax officers and invest them with all the powers under the Central Goods and Services Act and the IGST Act and the rules made thereunder throughout the territory of India. Now, this is where I think is our whole crux of discussion, that when they are assigned or notified to be the proper officers, it is fine. We don't have a problem. But if a person, a DGGI is sitting in Mumbai, does that DGGI has that pan-India jurisdiction to even take action in any part of the country? This is what I think is our first and the major part of discussion. Just to take you through this table, what it says, as are exercisable by central tax officers of the corresponding rank as notified in column 3 of the said table. So column 3 of the said table is officer whose powers are to be exercised, and these officers' powers are to be exercised by the officers of the DGGI. So for example, in the first serial number, you can see the principal director of DGGI will be empowered to exercise the powers of the principal chief commissioner. Similarly, the Director General Audit will exercise the power of Chief Commissioner. Fine. Again, Principal Additional Director, that is ADG, DGGI, will exercise the power of Principal Commissioner and so on. So this is how they have equated the DGGI officers with the respective central officers. And we have already seen in the previous notification that the central officers were already empowered on the basis of the territorial jurisdiction, and then this notification equates the respective powers of the central officers with the DGGI corresponding authorities. So this is, you can say, a brief background of how the entire DGGI comes into the picture. Now I'll take it to Shefali ji to take ahead this particular discussion, maybe with some practical case studies, so that we can have discussion on each of these pointers.
So as we can see, in the initial phase of GST, there was a question like whether the DGGI is having the power of not just doing the investigation, but sending the notices and doing the adjudication function also. And in some of the cases, like generally they react on some kind of intel, or they generally have a lot of information already connected. They will have some kind of background work, homework without doing any task. But in some of the cases, they were just expanding their horizon, and after that the government itself issued a particular notification, a circular was there, advisory types, and there they said that they should not try to expand their horizon, because see, uh, although in law there is not a differentiation between the cases which will be taken up by the normal officers and the cases which will be taken up by the GGGI, but fundamentally we have some differences. So if there is a work like resembling to audit or scrutiny, the DGI should not take up those kind of cases. They cannot do all of those tasks. Their thing will be when they get some kind of intel from the background, then they will do the investigation. And once they will complete the investigation, then cases will be handled accordingly. They can send the notices, SCN they can issue. Earlier, this was also a question whether they can issue the show cause notice or not. And I think Femina India, there was a judgment which clarified this, although it was already given in a notification that they can issue the show cause notices, but it was also clarified in that particular judgment. Now, the question is whether the DGGI have all the powers of an assessing officer, whether they can also do the adjudication and not just sending the notices. And if they can, then what will be the scope? Like if a particular DGGI unit is taking up an investigation, so generally their cases are huge, and the taxpayer which they will be following, which they will be picking, they will have multiple registrations throughout the India. So whether the single unit of DGGI can take up all of the registrations all over India, or they will just investigate the case and then the cases will be transferred to their particular jurisdictions. So Avinash ji is available. Okay. So with this question, I will go back to Vishalji. So whether a single unit of DGGI can send the notice, not just do the investigation, but send the notices and adjudicate the cases of all over India. Say there are the multiple registrations, or they will have to transfer those cases to those particular units. What's your view on it?
Ma'am, I understand these all units like DGGI or the other agencies, these are only investigative agencies. So I understand that, yes, they may be empowered to undertake different types of investigation and even cover, let us say, CBI, ED, all these things, because tomorrow, I'm sure very soon when PMLA and Benami will be brought into play, these authorities also will find commonly in many of our GST cases. So the point is, I understand that all these authorities are investigative authorities, and yes, maybe they may be assigned through various notification circulars the powers to investigate across India. But I think their power ends at the point where the investigation is over. I understand maximum they have the power to issue the show cause, but not the power to adjudicate. I believe and I understand that the adjudication power rests with the respective authorities who are assigned that particular powers through the parent notification, which we discussed at the start. This is my take on this, man.
Let us have a look on the notification which authorized the DGI officers to exercise all the powers of Central Tax Officer. I think it was 14 by 2017. Can we read it down? I think somewhere in this notification it is mentioned that DGI can only issue the show cause notice. Must be somewhere else. But if we read here in the starting of this particular notification, appoint the officers of Director General of DGGI as Central Tax Officer and invest them with all the powers under the Central Goods and Services Tax and the Integrated Goods and Services Tax and the rules made thereunder throughout the territory of India. I'm just trying to understand when they say all of the powers throughout the territory of India. So what do they mean? I mean, it means that any officer, any DGJ officer in any zonal unit, because they are divided into different zonal units all over India. So any DGJ officer of any zonal unit can investigate any case, whether it is falling in their particular zonal unit or at somewhere else. Because in DGI cases, sometimes that happens, like I summon someone, or say if it's a fake invoicing case, or if it's some kind of, I will say some nexus, some case having the nexus to the different states of India. And some unit of, say, Ahmedabad got an information or intel about a particular unit in, say, Telangana. So whether they will have to transfer that particular case to that Telangana unit, or they will investigate it all over India. Because when they are saying that they have the power throughout the territory of India, it means that every DGI officer has the power through the whole territory of India, or it means that different zonal units have the power in their respective areas. What's your thought on it?
Ma'am, I understand that their power is restricted only up to investigation. Even though this notification says that they have all the powers, I was just reading through again when you pointed out this point. I think we should take Avinashji's view on this first.
I'm in High Court right now. I'll join in 10 minutes.
Okay.
No worries. One second.
Yes, ma'am.
Vijay, can you search this circular number 31/5/2018?
Circular, that is there, ma'am. I have taken that circular also. 1 second. Yeah, it is there.
I think in this circular, they mentioned that their power is only to issue a show cause notice. Can we quickly go through it?
Yes. See here up to this point, it is about the monetary limit. This is this particular point which you are talking about.
Yes.
But it starts with in respect of show cause notices issued by the officer of DGGI. There may be cases where a show cause notice is issued to multiple notices, either having the same or different PAN, or multiple show cause notices are issued to the on the same issue to the multiple notices having the same PAN. So basically, either they are different assessees or they are multiple GSTINs but belonging to single PAN, means distinct persons of the same company. What it says in the principle. Sorry.
One second. Read para number 6. Six,
Yeah.
six.
So the central officers of Audit Commissionerate and DGGI shall exercise the power only to issue show cause notice. Okay, so you wanted to this point.
Yes,
So
yes.
shall exercise the power only to issue show cause notices. A show cause notice issued by them shall be adjudicated by the competent central tax officer of the executive commissionerate in whose jurisdiction. So, ma'am, this is exactly what I was mentioning.
Hmm.
That see, anyways, by nature also, I was reading there on their website. If you read the website of DGGI, you'll find that the website also has in the detailings of the DGGI has categorically mentioned that these are investigative agencies. More importantly, their role is to bring out the information and details what would be helpful to the other respective authorities to take their appropriate action. And what I believe is the previous notification which we were discussing, notification number 14, that was added so that tomorrow none of their investigative action should be challenged on the constitutional validity, that whether they have that power to take that investigative action or not. So this is my understanding. Means technically this particular point also, which I think once Avinash Bhai gets free, uh, can this particular circular empower them to even issue notice? I have this is my particular question relating to these investigative agencies. My
Uh-huh.
understanding till date is that the roles and the powers of these investigative agencies, whoever they are, is limited only to do the investigation and hand over the details to the respective authorities. But yes, here as we can see in para 6, they have been empowered to issue show cause also. Yes, ma'am.
So that's an important question. So, like, as we understand from the inherent nature of So, as we understand from the inherent power of DGGI, that they are specifically made for a purpose, and their purpose is to investigate the different cases. And sometimes they may not even have the required eligibility or knowledge to adjudicate a particular case. So, I think for the sake of easiness, in a particular notification 14, notification 14 by 2017 or 18, whatever it was, they said that all of the power of central officers will be with the DGGI, but it was only just like to avoid any kind of conflicts. But here they have clarified that DGGI can investigate and then they can issue the show cause notice. But by what we are reading till now, we can conclude that they can just investigate and issue show cause notice. And after that, the adjudication that will be done by their jurisdictional officer. It may be central, it may be state. Is it what you have concluded, or you have some other thoughts?
See, one point from my side, when we read that notification, the 14 notification, which says all the powers, I believe what they are trying to say, all the powers means all powers of investigation, wherever they are, whether it is 67 or powers to summon or any such powers, those I think all the powers they are mentioning, which I think the first impression says all powers means power to do everything, even do assessment, right? But I
Yes.
believe when they are saying all the powers, their intention is that when you are an investigative agency, I am giving you all the powers means all the powers for all types of investigations that are possible, which includes summoning, which includes conducting any type of raid or any such action. This is what is my reading of that particular point, all the powers. And then you can say this para 6 culminates that power into concluding it with issuing the show cause. This is how I read that particular entire point.
So can we say that the DGI is having the power from starting the investigation to making the grounds and issue a show cause notice,
Yeah.
and after that the power will be shifted to the adjudicating authority, the respective adjudicating authority, whatever it is.
Yes, yes. In fact, I think 6, 7.1 combined reading gives the same impression.
Yes.
Like 6 is
Hmm.
for independent cases, 7 is for multiple noticee cases. In either of these points, they are trying to highlight and bring out the same point only.
7 is about
It is about the multiple noticee. It is
if there
mainly
are
like the
multiple
fake
states,
invoicing.
then it will be shifted to the state of highest value.
Yes, yes,
And
that is what is the point.
I think Avinash is available.
Yes, so we can have his the net precise views on this. Yes, Avinash, over to you.
Yes, yes. What is the query?
So we were
We're
discussing about
discussing about the extent of powers of DGGI, to what extent they can exercise power. We went through the notification which says that it shall have all the powers equivalent to that of the respective central officers. And then we culminated our discussion up to this circular, which says that they shall have power to issue notice. So this is where myself and Shefali ji were having this discussion as to what extent is the expanse of the powers of the DGGI, whether they can exercise powers under all these sections, and where it will have a full stop.
See, what I understand is DGGI is nothing but an intelligence unit. Intelligence unit means to gather, their primary responsibility is to gather intelligence of tax evasion or revenue leakage or whatsoever name we can give. And after gathering that intelligence and assimilating the evidences, they can take action against the taxpayers. Now, when I say action against the taxpayers, it doesn't mean registered person. It can be against any person against whom they have the reason to believe that yes, there is some short payment of tax or maybe the tax evasion. So therefore, one thing is very clear: any action which is not based on intelligence does not come within the purview of GST DGGI. DGGI has the power of taking actions against the persons only when there is an intelligence gathered by them. So something which is there apparent from the record, and if DGGI is taking action, we can very well say that DGGI is no locus. Even DGGI has issued certain clarifications and notifications wherein they have said that, let's say if I'm registered in X state, let's say in Maharashtra, and I'm also registered in Delhi, and there is a DGGI Chandigarh, because we are understanding this as an all India feature. They have the power to adjudicate, or rather, I'm sorry, not adjudicate, but they have the power to investigate across the country. They have the power, meaning thereby the territorial jurisdiction is not applicable to them. That is what we mean to say. So therefore, a person sitting at Chandigarh is taking an action against the person sitting in Bombay and issuing a show cause notice to Delhi number. So what they have said is, although they do not have the territorial jurisdiction, but if it is something which is already recorded in books and because of that the action is being taken, then the territorial jurisdiction will be applicable. And therefore, a person sitting at Chandigarh DGGI will not be in a position to issue a notice against the person who is sitting at Mumbai. Mumbai DGGI can take action against that. So there are such kind of clarification and notifications which they have issued as a DGGI unit. Anyways, not going into that. Yes, it is correct that they have broad powers, but subject to investigation only. They cannot go beyond investigation. And therefore, we can also put a way to a term proper officer. As you all are aware that Canon India, Honorable Apex Court has said that a DRE officer is not a proper officer. And thereafter, a review was filed before the Apex Court, and then it was overturned in the review. And then it was said that proper officer is also the DRI officer. And in the meanwhile, in the interregnum period, the Customs Act was also amended. The point here is the term proper officer, which is specified in law, gives the power only to the commissioner or the commissioner sitting in board. So commissioner who is sitting in board, he has the power to authorize the people who can do or who can take actions as the proper officer. And there is no notification till date or circular issued by the board saying that DGGI is an authority or is a proper officer for section 73, 74, maybe 122, 129, or whatsoever sections are there. So number one, it is very clear that they are investigating authority. There is no circular, there is no notification by the board saying or authorizing DGGI to be a proper officer, number one. Number two, there is a Latin maxim, nemo judex in causa sua, which says a person cannot be judged on his own. meaning thereby a person who has the power of investigation or person who is doing the investigation works cannot sit and adjudicate. अदरवाइज तो वो यही ऑर्डर देगा कि मैंने इन्वेस्टिगेट किया था साहब, इसने गलत किया है, ही इज अ टैक्स इवेडर, इसको 15 साल के लिए अंदर डाल दीजिए, इसके साथ रिकवरी करिए इंटरेस्ट एंड पेनल्टी के साथ. दैट इज नॉट परमिसिबल. देयर हैज टू बी एन इंडिपेंडेंट एंड फेयर हियरिंग. An unbiased mindset has to be applied to adjudicate an allegation, and therefore DGGI is an authority who is investigating agency, and therefore it can never be possible that an investigating authority is also empowered to adjudicate the matters. So therefore you are reading in the para 6, I think it is of circular number 31, which says that they can only issue a notice, and it goes one step ahead also. Even this is applicable for the audit commissionerates. They can also only issue notice, even they cannot adjudicate. And therefore one thing is very clear, that DGGI being an investigative agency, audit commissionerates being the agency who is only empowered to do the audit or conduct the audits, are merely responsible to place their allegations on record, issue a show cause notice, and then hand over the adjudication process to an independent person as per various notifications or circular is issued by the board that let them decide. So adjudication process certainly cannot be done by DGJ. Yes.
So for our viewers, if I divide it, मैं पूरे DGGI के और एक normal adjudication के functions को divide करूँ by section wise, so DGGI will get some kind of intel, and what they can do search 67 कर सकते हैं, वो 69 132 वाला अरेस्ट कर सकते हैं, समन कर सकते हैं 70. those powers are with DGGI. प्योर सेक्शन रहेगा इन्वेस्टिगेशन का विशाल?
Sorry?
कोई और सेक्शन अभी इन्वेस्टिगेशन वाला रह गया क्या इसमें?
नहीं,
67
I don't think so.
32
Yes.
70 समन,
Yes.
वो सब वो कर सकते हैं. ये सारा हमारे DGGI के पावर्स के अंदर आएगा. और इसके बाद जब एडजुडिकेशन वाले पार्ट पे जब हम लोग जाएंगे, तो समटाइम्स दैट में हैपन कि एडजुडिकेशन तो बाद में हो रहा है, लेकिन DGGI ने डायरेक्ट अरेस्ट ही कर लिया और अब केस हमारा जो था वो एडजुडिकेशन से कोर्ट के साइड मूव हो गया. तो वहां पे हमारा कैसे कोर्स ऑफ एक्शन रहेगा अविनाश जी? की जैसे सीधा समन के लिए बुलाया, उन्होंने अरेस्ट कर लिया, सर्च प्रोसीडिंग में सर्च के टाइम पे उन्होंने अरेस्ट कर लिया, देन आर सेकंड प्रोसेस विल बी कि हम लोग अब बेल के लिए जाएंगे. तो फिर वहां पे DGGI का रोल कहाँ तक रहेगा और कहाँ पे फिर शिफ्ट होके वापस वो एडजुडिकेशन पे आएगा?
See, please understand, abhi ek notification, if I'm not wrong, was being shown by Vishal bhai, wherein the question was being shown if he's a additional director general, he is equivalent to joint commissioner, or if he is a principal director, additional director general, he is equivalent to the commissioner. So all those powers which those authorities are having will automatically get vested in the DGGI authorities. See, the only point which I am trying to raise is that if I am an investigating authority, I need not be a proper officer, but they can come out with a notification later in point in time after this canon India, and they can say that DGGI officers are also proper officers. Then the DGGI can adjudicate also. But for the time being, I'm of the view that whatever powers are vested with these authorities who are there in column number 3 automatically gets vested with the officers of DGGI in column number 2. So now there is a requirement of a separate notification saying that 73, 74 proper officer are DGGI authorities, or the deputy director of DGGI or additional director of DGGI. Till that time, we can take the cognizance of clause 91 of section 2 and say that they are not proper officers, because either proper officer is a person who is a commissioner or a person who is nominated by for a particular function by the commissioner in board, and therefore he is not till date notified to be so. So my only answer would be DGGI can certainly take actions of search and seizure because they are equated with the commissioners, and therefore the additional director general can certainly issue a search warrant. They can go for the attachment of the properties because section 83 also empowers a commissioner, and now additional director general is equated with the commissioner, and therefore he can take that action. They can certainly arrest a person because again the commissioner is there, and commissioner is now equated with the DGJ office authority, and therefore he is the power, he is the person who can certainly issue the arrest warrant. But when it comes to 73 or 74 or stepping into the sea, there are two terms in law. One is proper officer and the other term is adjudicating authority. So when we see section 74, let us just see section 74. It says when it appears to the proper officer, and when it comes to appeal, you will find adjudicating authority, section 107. Let me just take section 107. Any person aggrieved by any decision or order passed under the act, so and so, by an adjudicating authority. So these two terms needs to be taken care of. A DGJ authority, when he, let's say he pass an order, which is an appealable order, stepping into the shoes as an adjudicating authority, that is appealable order and he can do that. For example, blocking of your ITC, Rule 86 capital A, that can be done by a DGJ authority and it is appealable. You can go and file appeal against that. It never says commissioner has the reasons to believe. Whereas section 83 gives the power to the commissioner, and those powers can certainly be delegated as per various judgments. But I am of the view that all those powers being delegated also will be considered to be an order of the commissioner itself, and therefore that cannot be appealed against. आप 107 में उसकी अपील फाइल नहीं कर सकते, तो he can never be an adjudicating authority, and therefore proper officer के लिए clause 91 of section 2 is important, which says either the commissioner or a person who is assigned the function by the commissioner and board. So unless there is a notification by the board saying that 73 and 74 can be done by the DGJ authority also, I am of the view he cannot do anything with relation to the adjudication under 73 or 74 or any other section. But certainly he can arrest, he can do the search proceedings, he can attach. All those powers are certainly vested with the DGJ authorities. Because I once again will reiterate my submission just for the sake of convenience. When I am saying that an additional director general is equivalent to the commissioner, it means that all the functions which are assigned to a commissioner by virtue of a circular, let's say circular number 3, may it be registration, may it be 122, may it be 129, whatsoever, whatever power has been given to the commissioner automatically vests with the additional director general. So all those powers are with him under all the provisions of the act. But since a proper officer is required to adjudicate a particular matter under 73, 74, and they are not a proper officer, therefore I personally believe that they cannot adjudicate, even if they are equated with the authorities.
Avinash ji, एक ना थोड़ा सा it's a different question. Maybe we can remove it from the recording later on when we will publish it. जो GST ऑफिसर्स की पावर है वो ठीक है हमने DGI को भी दी है, बट अपार्ट फ्रॉम दैट क्या एज एन इन्वेस्टिगेटिंग एजेंसी उनके पास कोई और एडिशनल पावर्स भी है? बिकॉज व्हेन पीपल विजिट द DGI ऑफिस दे आर थ्रेटन्ड, बहुत डर होता है।
Why to remove this from recording? This is a fact which is going on.
नहीं, मैं शायद
we at Ashwa Legal have to be bold enough to speak out all those things.
Because sometimes they force. Sometimes when you are visiting DGI, they force. Sometimes they make you sit for long hours, and sometimes they even raise hands and do something like that. So is it under their power? Do they have some different kind of power, like of a police officer or something like that they can hit someone or they can force someone to make them record their statement, or their powers are just as like any other GST officer?
My understanding of the law, whatever I have read a bit, I can only say that no one in this country has the power to abuse physically anyone. No one. Forget about the police officer, forget about DGJ authorities.
Right.
But that is what is merely abuse of power. And unfortunately, nobody comes forward. to say that these powers are being used and or misused or whatsoever abuse is there. Because in most of the cases, I have found that the taxpayer against whom such powers are being used are hand in gloves, are certainly involved in such kind of tax evasions. So they are also afraid. But anyways, going for the legal view, my personal understanding is, number one, they cannot do any such act. Number two, there is an important and landmark judgment of Honorable Apex Court, which is Paramveer Singh Saini. It says that any authority, may it be police, may it be CBI, may it be DGGI, may it be state authorities or central GST authorities, or whosoever, who has the power to arrest, must do the interrogation or recording of a statement within CCTV recording. And that CCTV recording must be preserved for minimum 6 months. Minimum 6 months. So that is what the Paramveer Singh Saini, the Honorable Apex Court says. And it says it has to be installed compulsorily at all those places where the interrogation is being taken by these authorities. And therefore, the taxpayer who is summoned by the DGGI authorities or central GST authority or state authority, and his statement is being recorded, he must ensure whether the cameras are there, whether the recording is happening or not. If not, then he has the right to question the interrogation, that it is not in accordance with Paramveer Saini as per the Apex Court, and therefore he can, if he has the guts, he can move out, or he can get his statement recorded and immediately he can go out and file a retraction saying that my statement was recorded under coercion. And the compulsory or mandated procedure for recording the statement by an authority who has the power to arrest is not followed, and therefore it is a contempt against the order of the Apex Court. But I don't know how many of the taxpayers are having that guts. Because हम तो जाते हैं वहां पे सर करने के लिए, हम वहां जाते हैं कि वो हमें कुछ oblige कर दें. That is the reality of this. And most of the professionals are engaged in that. So who will go and say कि सर आपने इंस्टॉल नहीं किया हुआ है. वो तो जब उनकी बात नहीं होती है, या उनका, आई एम सॉरी टू से यूज दिस वर्ड, बट उनका जब सेटिंग खराब हो जाता है या सेट नहीं हो पाता, तब ये सब इश्यूज आते हैं और तब तक बहुत डिले हो जाता है. सो लॉ तो सबके लिए बने हैं मैडम, पावर भी सबके डिफाइंड है, लेकिन हम में से किसी के पास वो गट्स नहीं है कि हम जाके उसको बोलें कि आप गलत कर रहे हैं. दैट इज द अनफॉर्चुनेट पार्ट.
You're right, Avinash, but knowledge is also power. मेरे ख्याल से जो मोस्टली चार्टर्ड अकाउंटेंट्स स्पेसिफिकली, उनको कई बार पता नहीं होता कि क्या डीजीजीआई का पावर है. टैक्स पेयर हो चाहे कंसल्टेंट है, दोनों ही एक दिमाग में थोड़ा सा फियर होता है कि आप डीजीजीआई जा रहे हो. टैक्स पेयर को ये लगता है कि मेरे को यहीं से अरेस्ट ना कर लें, यहीं से कोई मेरा कोई टॉर्चर तो स्टार्ट नहीं हो जाएगा. एंड समटाइम्स दे क्रिएट अ मेंटल प्रेशर. मतलब मेंटल प्रेशर में दे विल से कि हम ये कर देंगे, वो कर देंगे. ऐसा कुछ कर नहीं सकते और करते भी नहीं है, बट दे विल से, एंड मैनी ऑफ द टैक्स पेयर विल फॉल फॉर इट कि भाई चलो ठीक है, आगे क्या है. समटाइम्स इट विल बी लाइक काइंड ऑफ एडवाइजरी फ्रॉम देयर साइड कि या तो आप इतना इतना कर दो, वरना भी केस बनेगा, वैसा बनेगा, इतना कुछ हो जाएगा इसके अंदर. सो दे हैव बोथ ऑफ द स्किल्स, और फिजिकल भी उनका और मेंटली भी लोगों को एक मैनिपुलेट करने का होता है उनका स्किल्स. बट ऑल ऑफ द प्रोफेशनल्स हु आर वाचिंग दिस पर्टिकुलर वीडियो, ये क्वेश्चन मैंने स्पेसिफिकली इसलिए पूछा है कि जिनको बहुत डर होता है कि हम डीजीजीआई विजिट करेंगे तो पता नहीं क्या हो जाएगा. सो एटलीस्ट यू ऑल अंडरस्टैंड द राइट डीजीजीआई है. उनको कोई पावर या उनकी राइट जो जीएसटी ऑफिसर्स आपको नॉर्मली आपसे क्वेश्चनिंग कर रहे हैं उनसे बहुत ज्यादा नहीं है. दे कैन इन्वेस्टिगेट, बट दे कैन नॉट मेक एनी फिजिकल हार्म अगेंस्ट यू. एंड जो बहुत इंपॉर्टेंट चीज अविनाश जी ने बताई कि अब ये मैंडेटरी है कि आपको जब वो इन्वेस्टिगेट कर रहे हैं, इट शुड बी रिकॉर्डेड अंडर द कैमरा. वो रिकॉर्डिंग होनी चाहिए किसी भी तरह का मैनिपुलेशन को स्टॉप करने के लिए. सो आई थिंक दिस वाज वेरी इंपॉर्टेंट पॉइंट, क्योंकि जब मैं इस पे बात कर रही थी तो काफी चार्टर्ड अकाउंटेंट से मेरी बात हुई, एंड दैट सेड कि नहीं डीजीआई तो हम जाते ही नहीं है, वो ऐसा करते हैं, वैसा करते हैं, ये करते हैं.
मैडम एक छोटी सी चीज ऐड करना चाहता हूँ जो आपने बोला, उसी में एक एडिशन कॉम्प्लीमेंट करना चाहता हूँ कि डीजीजीआई के पास कोई भी एक्स्ट्रा पावर नहीं है.
दैट्स वेरी इंपॉर्टेंट.
कोई भी एक्स्ट्रा पावर नहीं है. जो एक स्टेट जीएसटी ऑफिसर के पास है, जो एक सेंट्रल जीएसटी ऑफिसर के पास है, वो सारी पावर्स ही उनके पास है. उससे एक पर्सन भी एक्स्ट्रा नहीं है. केवल फर्क इतना है कि उनका टेरिटोरियल जुरिस्डिक्शन का लिमिट्स नहीं, बाउंड्रीज नहीं. दे कैन इन्वेस्टिगेट अक्रॉस इंडिया, बस. इसके अलावा दे डू नॉट हैव एनी एडिशनल पावर, तो देयरफॉर नो नीड टू बी अफ्रेड। और प्लस यही सेंट्रल जीएसटी ऑफिसर ही वहां पे डेपुटेशन में जाते हैं 2 साल 3 साल के लिए, यही ऑफिसर होते हैं। इफ यू आर
Yes,
नॉट
yes.
अफ्रेड विद द सेंट्रल जीएसटी ऑफिसर, व्हाई यू आर अफ्रेड विद डीजीजीआई?
Mhm.
मियरली वो माइंड में हमने बना लिया है कि इंटेलिजेंस विंग है। पहली बात तो आप अगर ये नॉर्मल में आ जाते हैं, फॉर एग्जांपल जहाँ पे इंटेलिजेंस की जरूरत ही नहीं है, और वहां पे डीजीजीआई ने कोई लेट्स से कोई क्लासिफिकेशन डिस्प्यूट है, तो अभी तो
Mhm.
सर्कुलर है, बहुत क्लियर है कि क्लासिफिकेशन
Yes,
डिस्प्यूट में डीजीजीआई कैन नॉट कम, so they
right.
cannot ask you to get your statement recorded because they do not have the locus. So we
Mhm.
have to be aware about where the GST DGGI has locus, where they do not have the locus, because intelligence based enforcement action ही वो कर
Mhm.
सकते हैं, other than that they cannot do any action. It has to be referred to the jurisdictional GST authorities or jurisdictional DGGI authorities. अभी
Right.
लोग इसलिए हरेस होते हैं ना, क्योंकि मैं तो यहाँ बैठा हूँ गुजरात में, अभी वो
जी.
चंडीगढ़ वाला मेरे को नोटिस समन भेजेगा तो मुझे वहां जाना पड़ेगा। सो आई
Mhm.
आई आई एम बिट रिलक्टेंट टू डू दैट, आई एम
Mhm.
अफ्रेड। बट देन वी नीड टू सी कि वो क्या, कौन सी चीज के अगेंस्ट में मेरे लिए एक्शन ले रहा है। इफ दैट इज
Mhm.
नॉट इंटेलिजेंस बेस्ड, देन आई कैन सर्टनली से कि प्लीज ट्रांसफर द प्रोसीडिंग्स टू दिस, टू द स्टेट ऑफ गुजरात एंड आई विल अपीयर बिफोर द डीजीजीआई गुजरात।
Right.
एक सॉरी 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 एक चीज और जस्ट क्लिक हुई है तो मैं भूल जाऊंगा। डीजीजीआई के पास क्यों ऑल इंडिया जुरिस्डिक्शन है वो भी पता होना चाहिए, बिकॉज दे आर डिपेंडेंट और दे आर empowered to conduct intelligence based enforcement action, issue based. Say for example there is an issue which creeped up, let's say at Delhi. अब एक इशू जो दिल्ली में आया, वही इशू पूरी इंडिया में है या नहीं है, या फिर
Mhm.
एक इंसान जो दिल्ली में रजिस्टर्ड है और 22 स्टेट में रजिस्टर्ड है, इन स्पाइट ऑफ गिविंग दैट इंक्वायरी टू दी 22 स्टेट्स एंड देन टेकिंग एक्शन बाय दी 22 स्टेट अथॉरिटीज, डीजीजे हैज द पावर दैट आप 22 स्टेट्स का एक ही जगह से इन्वेस्टिगेशन कर सकते हो। दैट इज द ओनली डिफरेंस, अदरवाइज देयर इज नो डिफरेंस। क्योंकि सेंट्रल जीएसटी वाला दिल्ली में बैठा होगा तो वो गुजरात में आके इन्वेस्टिगेशन नहीं कर सकता, इट इज नॉट विद इन पावर, बट
Mhm.
डीजीजीआई वाला कर सकता है। इसलिए सेंट्रल वाला भी डीजीजीआई को इंक्वायरी देगा कि सर इनका 22 जगह रजिस्ट्रेशन है डिफरेंट स्टेट्स में, एंड देन डीजीजीआई कैन टेक अप दैट। सो दैट इज अ टेरिटोरियल और इट इज एन इशू बेस्ड, कि कोई
Mhm.
इशू उठा है, फॉर एग्जांपल ऑनलाइन गेमिंग, आज सुप्रीम कोर्ट में हियरिंग चल रही थी उसकी,
Mhm.
ऑनलाइन गेमिंग। सो अक्रॉस इंडिया ऑनलाइन गेमिंग में वो इशू चल रहा है, तो डीजीजीआई कैन टेक एक्शन सिटिंग इन दिल्ली।
Okay.
दैट इज हाउ इट इज।
जैसे इंश्योरेंस कंपनीज को पीछे बहुत सारे नोटिस डीजीआई ने दिए। ओके, विशाल आपको ऐड करना है इसमें कुछ?
Yeah, I have one point in this. Firstly, let me take the question which is there in the chat box. It is by Rajesh ji. Whether the intelligence has to be shared by DGGI during interrogation.
नो, नो, दे आर नॉट बाउंड टू, बिकॉज इंटेलिजेंस इज रीजन टू बिलीव।
Now, as we were discussing about this powers of DGGI, and as Shefali ji pointed out that there is a lot of misuse or use of wrong language or harsh language. Now, the point is that is there any sort of relief in the sense, first immediately let us say I go there, let us say I'm summoned, or they come to my office for any type of investigation, can I plead any type of relief, maybe medical grounds or any type of, let us say, social reasons, family reasons? Will I get that leave at that particular time?
See, this is again a settled law. Lot of jurisprudence is there which says अगर आपको डर लग रहा है तो आप एडवोकेट को बुला सकते हैं, चार्टर्ड अकाउंटेंट को अगर परमिट करते हैं तो बुला सकते हैं, जो एक डिस्टेंस पे खड़े रहेंगे
Mhm.
जहां से वो प्रोसीडिंग्स देख सकता है लेकिन वो सुन नहीं सकता है।
Mhm.
इसी तरीके से अगर आपका मेडिकल ग्राउंड्स पे है तो यू कैन रिक्वेस्ट देम, दे विल टेक यू टू द मेडिकल फैसिलिटी,
Mhm.
they will confirm with the doctor. If doctor says that yes there is some problem, then they will have to provide a relief to you. They cannot go beyond that, provided that is not an excuse. अगर आप जो कर रहे हैं, प्लीड कर रहे हैं, if that is a genuine cause, then certainly it will be permitted. But to be very honest, they never permit that.
Yeah, that is what is the point. Like I got a practical case where a particular taxpayer who was having a diabetic problem. Now they gave you the time of morning 10 o'clock, and until 5 there was no response from their side. This person was sitting. He was not aware that he would be made to sit for such long hours, so he was not carrying his respective pills. Now, when he requested, firstly, he requested he kindly ask the officer to take me in and do the investigation or someone whatever. That was not honored. Then he requested that let me go and have my pills and come back, or maybe I'll come back other day. The person sitting there specifically said that if you leave right now, it will be considered that you are not present and you have abused the particular summons. So this is how what is happening practically at a very minute level. So this is what everyone is facing the challenge, or you can say the heat of that particular powers that they are using.
विशाल जी, एक बात शेयर करता हूँ. मैं हमेशा अपने हर सेशन में जहाँ पे मौका मिलता है बोलता हूँ कि अगर किसी को पावर दी गई है तो वी हैव टू ऑप्शंस, टू यूज दैट पावर वाइजली और टू मिस यूज दैट पावर. इसी तरीके से हमें प्रिविलेज अगर दिया गया है, वी हैव द privilege of, let's say, anything, a personal hearing, then again we are misusing or using it wisely or unwisely. So this is dependent on person to person. We cannot like say ki every DGJ officer does that, and at the same time we cannot say that every DGJ officer is a good officer. It happens because they have the intelligence. And plus understand, क्योंकि मेरे बहुत सारे friends भी थे, हैं अभी जो डिपार्टमेंट में है, they have a concern कि आप अगर किसी से प्यार से बोलते हैं, he will never admit. He admits only when you show your powers. This may be wrong, but finally you have to get the case or the intelligence cracked and admitted. So I do not see any anything bad in that, unless or until they go for the physical abuse. Till the time they are pressurizing you, they are creating a pressure. सर 10 बजे से 5 बजे तक वो इसलिए बिठाते हैं क्योंकि दे वांट टू टेस्ट योर पेशेंस एंड दे वांट टू पुट यू अंडर प्रेशर कि यार मैं कहाँ फंस गया. Because there is huge pressure sitting idle with no work, and that too in the DGJ environment.
Right.
So therefore, I personally believe that we can avoid all those things or all these things. It is subjective, it is case to case basis, but on a broader perspective, we can certainly say that they have the powers which every intelligence officer has, may it be a police officer, may it be a central GST officer or an income tax officer. Nothing beyond that. उसके ऊपर कुछ भी कर रहा है, then it depends on your guts that how do we address it. And so far as your reliefs are concerned, I am of the view that all those reliefs, चाहे वो medical relief हो, चाहे वो आपका health उस वक्त खराब हो गया हो, आपकी anxiety बढ़ गई हो, आपको कोई medicine चाहिए हो, it is mandatory as per the CRPC also that during the search operations, if any such kind of things happen, then you will have to provide that. और उसका बेस्ट एग्जांपल और आंसर कैन बी दी पंचनामा. पंचनामा ड्रॉ किया जाता है मैंडेटरीली हर सर्च के बाद, जिसमें पूरी प्रोसीडिंग्स लिखी जाती है. तो उन्हीं प्रोसीडिंग्स में वो भी रिकॉर्ड होगा कि सर मैंने मांगा था, एंड पंचनामा हैज टू बी साइंड बाय द पर्सन एंड द अथॉरिटी एंड द पंचेस. तो वी कैन वेरी वेल रिकॉर्ड कि सर मैंने दवाई के लिए टाइम मांगा था, उन्होंने दवाई के लिए टाइम नहीं दिया मुझे. मैंने बिल लेने के लिए बोला था कि मैं बिल लेके आता हूँ, लेकिन उन्होंने मुझे परमिट नहीं किया. Record that in Panchnama and take it ahead to the courts. I hope I am clear.
Yes, yes. विनाश जी ने एक बड़ी अच्छी बात बोली कि ना इसमें एक बैलेंस, मुझे लगता है विशाल जी बहुत इंपॉर्टेंट है. मतलब ये भी ना हो कि एसएससी उसका बेनिफिट ही लेने लगे कि मुझे सुबह से बिठा रखा है तो मैं नहीं कर पा रहा हूँ. मतलब मैंने एक जजमेंट में ऐसा पढ़ा था कि इवन क्रिमिनल में ना वो फिर भी अलाउ कर देते हैं फैमिली मेंबर्स को आसपास पूछताछ के लिए, बट फाइनेंशियल क्राइम में नहीं करते क्योंकि आपको बहुत अच्छा एनवायरनमेंट मिल रहा है कि आप झूठ ही बोल सकते हो. योर फैमिली मेंबर्स आर देयर, आपका लॉयर है, वो आपको सुन भी रहा है, वो आपको गाइड कर रहा है. फिर तो आप कभी एडमिट करोगे नहीं कि आपने कोई फाइनेंशियल क्राइम किया है. तो इसलिए लॉयर का भी ये है कि वो आपको देख तो सकते हैं प्रोसीडिंग्स के दौरान, बट सुन नहीं सकते कि आप क्या करें, आपको इन्फ्लुएंस नहीं कर सकते. सो यहाँ पे
चूड़ामणि का
बैलेंस.
जजमेंट है.
जी जी, चूड़ामणि परमेश्वर है. तो यहाँ पे एक बैलेंस बहुत इंपॉर्टेंट है कि ऐसा भी ना हो कि टैक्स पेयर भी उन चीजों का डिसएडवांटेज स्टार्ट कर दे कि भैया मैं हमेशा ही बोल दूं कि अच्छा मेरे को तो बहुत ज्यादा एंग्जाइटी हो रही है, मेरी तबीयत खराब हो रही है, और ऐसा भी ना हो कि उसका जेन्युइन प्रॉब्लम है और तब भी हम उसको रिलीफ ना दें. एंड आई थिंक जो अविनाश जी ने बोला ना कि ये जो सब्जेक्टिव चीजें होती है ना वो हमेशा पर्सन टू पर्सन डिपेंड करती हैं. कहीं पे ऑफिसर हो सकता है ज्यादा एग्रेसिव हो, कहीं पे टैक्स पेयर हो सकता है ज्यादा श्रीवुड हो कि वही उसका बेनिफिट लेने का कोशिश कर रहा है. तो ईच एंड एवरी केस राइट है हमारे पास, हम अवेल भी कर सकते हैं, बट वी विल हैव टू सी द फैक्ट्स ऑफ ईच एंड एवरी केस, सिचुएशन क्या बनती है उसमें.
There is one question, ma'am. Will you take up, please? Ma'am, there is
आई
one
थिंक
question.
अविनाश जी बेटर आंसर कर पाएंगे इस क्वेश्चन को. सर, इफ डीजीजीआई इन्वेस्टिगेशन कमेंसेस बेस्ड ऑन थर्ड पार्टी स्टेटमेंट, we can demand for cross examination of those parties.
No. When it comes to investigation, at investigation stage, you cannot ask for any cross examination. Once he completes an investigation, for example, अगर criminal में बोलता हूँ, तो once he files the charge sheet, then we can ask for the evidences and the examination of those evidences. Similarly, जब DGI या कोई भी authority, when they are issuing show cause notice, and they are relying on on the statements of those third parties, at that point in time, you can ask for the cross examination, not when DGI is during the course of investigation. That is not permissible.
सो आई थिंक आपको क्लियर हो गया. जैसे अविनाश जी बोला है कि दो स्टेजेस होते हैं. पहला हम जब सिर्फ इन्वेस्टिगेट कर रहे हैं, सेकंड जब हम ग्राउंड्स पहली बार राइट डाउन करते हैं कि ग्राउंड्स हमने क्या क्या बनाया, तो चाहे वो चार्जशीट हो चाहे मेरा एडजुडिकेशन हो. तो जब एडजुडिकेशन या चार्जशीट के लेवल पे है, एट दैट टाइम यू कैन आस्क फॉर क्रॉस एग्जामिनेशन, लेकिन उससे पहले आप नहीं कर सकते.
There is one more question. If proper officers of respective states have issued notices post DGGI investigation, will the proceedings of proper officer be subsumed with DGGI investigation? Asking since DGGI generally deals with issues related to intelligence only, as stated.
I need to answer?
Yeah.
See, again, 6(2)(b) can be referred, which says that if a person investigates or an agency starts the investigation first, then all other investigations need to be transferred to them only. So therefore, अगर DGI ने कोई start किया, तो state authority ने अगर same cause of action पे, for example, DGI started कि अविनाश से जो आपकी purchase थी वो bogus थी, और state ने start किया, I cannot name any of my friends' names, so I'll say A की purchases, A से जो purchase आपने की वो गलत थी. तो now there are two causes of action. One, अविनाश की purchases जो DGI ने किया. Two, A से purchases जो state ने किया. Both are allowed. Both are allowed. There are a lot of jurisprudence. GST के अंदर बहुत सारे judgments हैं. But when the cause of action is same, then subsequent agency cannot proceed further. It has to transfer. Now, in your case, what I understand is that the order is already passed by the state authorities. You can submit those orders to the DGGI, but my limited understanding says DGGI may not agree with that. कि नहीं हम तो इसको will issue fresh show cause notice. Then the option only would be to go to the High Court, say that on the same cause of action, state has already taken a cognizance and state has already decided. Now, either the DGGI should say that we do not trust the state authorities, or else they will have to do away with their right. Because now they cannot proceed further because it is already adjudicated. Now it is no more under investigation. So again, we need to have further deep look into the facts of the case, but this is how it can be handled.
नहीं, बट एक बार अगर एडजुडिकेट कर दिया स्टेट अथॉरिटी ने, तो क्या डीजीजीएफ को दोबारा एडजुडिकेट कर सकते हैं?
इसीलिए तो मैंने बोला ना कि वो नहीं कर सकता, लेकिन वो रुकेगा नहीं, क्योंकि उसको अपने डाउट्स होंगे, अपने अप्रीहेंशन होंगे. आप ही ने बोला कि वो अपने आप को थोड़ा सुपीरियर समझते हैं, और हम प्रोफेशनल भी उनको सुपीरियर मानते हैं, तो he will not agree with that. So therefore, the only option left would be to go to the court and say कि sir, see the cause of action is same. DGI जो कर रहा है वो स्टेट वालों ने ऑलरेडी कर दिया है. So either the court has to quash the state authorities order, or else they will have to stop the DGI authorities.
Great. I think all the questions are answered. So, okay, there is one more question by Rakesh ji. Where a taxpayer is called on summons at a given time, and even despite being on the time, the officers has to wait. Even after considerable time, the officers further has to wait. In such cases, what recourse are available with the taxpayer?
As per me, no recourse is available. See, he is an investigating officer. He is not working only on your case. He might be working on a number of cases. He might be collecting evidences, collecting intelligence on various cases. There are maybe he has given time of 10 a.m., but he's unable to take the statement or record the statement at 10 a.m. because of in number of reasons which he can record. This is what is a legal submission. But honestly, bole, so they are doing this intentionally. As we have already discussed, 10 से 5 बजे तक बिठाया, तो that is only to harass mentally. So one recourse can be कि आप 10 से 5 बैठिए और आप अपने किसी फ्रेंड को बोलिए कि unnecessarily detain किया हुआ है and go and file a petition of habeas corpus, unlawful detention of a person. अगर आपको 2 दिन बुला के बिठा रखा है, you can do that. Otherwise, the only recourse available with you is to request the authority कि सर जब आपको स्टेटमेंट आप रिकॉर्ड कराने होंगे तब आप मुझे बोलिएगा, मैं आ जाऊंगा. अदरवाइज प्लीज रिकॉर्ड इट एज सुन एज पॉसिबल. आप मर्सी पिटीशन फाइल कर सकते हो, आप मर्सी के लिए रिक्वेस्ट कर सकते हो, नथिंग बियॉन्ड दैट. लीगली यू कैनॉट डू इट बिकॉज ही इज एन इन्वेस्टिगेशन ऑफिसर एंड इन्वेस्टिगेशन रिक्वायर्स टाइम and requires his mental freedom also. You cannot force him to take the statement as per your peril because you are now accused.
अविनाश जी, ये तो डीजीजीआई में क्या है, डिपार्टमेंट में भी है. समटाइम्स व्हाट हैपेंस के कोई बाहर भी है, उसको हियरिंग के लिए डेट देंगे और उस दिन पता चला जिसके साथ हियरिंग है वो खुद ही छुट्टी पे है.
ये बहुत कॉमन है. बहुत
मैडम, हमने तो ऐसा देखा है, 1200 लोगों को एक ही शोकॉज दिया और एक ही टाइम दिया हियरिंग का. जस्ट इमेजिन 1200 लोगों की एक साथ हियरिंग कैसे कर रहा है वो, एक ही टाइम पे 11 बजे रात दिन में. This is how it is.
I'll unmute Yash ji. He has, I think, some question.
Sir,
Yes, Yash ji.
सर गुड इवनिंग सर. सर एक सर्कुलर है, सर्कुलर नंबर 31, जिसमें प्रॉपर ऑफिसर को पावर्स दिए गए हैं कि 73 एंड 74 में पर्टिकुलर अमाउंट जो आई और सी और एस है वो पर्टिकुलर अमाउंट के अंदर आपको नोटिस इश्यू करनी है. डिपेंडिंग मीन्स सुपरिटेंडेंट को इतनी अमाउंट तक, डेप्यूटी कमिश्नर को इतनी अमाउंट तक, जॉइंट कमिश्नर को इतनी अमाउंट तक. अगर किसी मैटर पे एक बार एससीएन इश्यू हो गया है और वो ड्रॉप हो गई है, कि क्या वो दोबारा वही मैटर के ऊपर, यानी वो मैटर एएसएमटी 10 में क्लोज हो गई थी, दोबारा एससीएन देकर वही मैटर को आगे फॉरवर्ड किया गया एससीएन के अंदर, और वहां पे वो जो एससीएन निकाली थी वो सुपरिटेंडेंट निकाली थी, बट अबो 1 करोड़ एंड 2 करोड़ अमाउंट थी. तो ये पर्टिकुलर, और उसका ऑर्डर भी पास हो गया है डीआरसी 07 का. तो पर्टिकुलरली ये सर्कुलर का मैं ग्राउंड ले सकता हूँ अपील के अंदर, और
100%. See, ASMT and these two are independent actions. So भले ASMT close हो गया है, first if the question is can he still raise 73, 74, I believe yes, but we are not right now going to deliberate on that because that is our third part of, let us say, jurisdiction series, that whether there can be multiple actions on similar issue. But right now, answering your question, if let us say at the time of issuing show cause, they are not fulfilling the criteria given in that particular circular of the monetary limits, then 100% the entire action is beyond the jurisdiction of the respective officer and it has to be challenged. In fact, this should be our main ground in the appeals.
तो सर अपेलेंट अथॉरिटी ये ग्राउंड्स मींस एक्सेप्ट करके मेरा जो ऑर्डर पास किया है वो सेटिस्फाइड हो सकता है कि क्या हो सकता है ये केस के अंदर सपोज?
Sir, an independent appellate authority should definitely consider this.
Okay, thank you, sir.
Yes.
अविनाश जी, आपको इस पे कुछ रिस्पॉन्ड करना?
नहीं.
ठीक है यश जी, तो आई थिंक योर क्वेश्चन इज आंसर्ड. अभी कोई और क्वेश्चन है विशाल?
नहीं, ma'am, it's done. So I think yes, it was really a great insightful discussion. And I'm sure everybody present here who had many questions about DGGI, many of them are addressed. And yes, jurisdiction in itself is a series that we are conducting. So this is part 2. We still have 2 more parts left. either some specific or either some generic. So that would be covered in due course. Maybe in the next month, the next part would be there. And also all the members who are present here, I'll request them that if you also have any particular issue, you may put it across to any one of us so that we can even craft a specific webinar on that particular issue, because that may be just a trigger point. Once you come to us with a particular issue, though we have our own calendar set on multiple issues to be discussed, but we can take up that issue. If it is very burning, we can even take up on priority so that it would benefit everyone who is viewing us either live or later on during the recordings. So I thank everyone who has taken out the time at a very peak hour of the day. And also, yes, sorry, we had to, because of some internal reason, shift our day from Friday to Thursday. But still, I thank everyone for being present here. I think Avinash Bhaiya wants to add something. Okay. So, yes, thank you, everyone. Thank you, Shefali ji. Thank you, Avinash Bhaiya. Thank you, Pramod ji. And yes, we shall be continuing our webinar series on different points. So be connected for the next session to come up. So with this, I think I'll take leave of everyone. Thank you very much.
Thank you,
Thank
Vishal.
you.
Good day, everyone.
Thank you, Avinash.
Thank you very much.
Thank you. Thank you.